there was really no book laws on the book about prohibiting gay behavior or gay marriage. There were sodomy laws all over the place. But in the late 70s, there was no like prohibition of marriage. Marriage didn't have a definition. There were no like explicit marriage laws that many of the states had before Obergefell came. Now, in the late 70s, a couple wanted to get married in San Francisco. That's where that fervor came up. It started brewing this anti gay sentiment. Now, mind you, it doesn't really matter for the conservative, the Republicans, to care about gay marriage or care about any of these social issues. They are just the biggest weak points, your biggest vulnerabilities. And the places where you're most emotional, the places where you spend the most time thinking or being scandalized by, they aren't the topics that put food on your table and a roof over your head. These are the topics that deal with your reputation, deal with your culture, deal with our identities, deal with how we live our daily lives, deal with our privacy and our daily usages and our um, relationships. They aren't this. That's what these rights are about. And as such, it started brewing that this may be a good way to distract the populace enough to create division. And I'm saying this because the substantive due process body of law comes from a very conservative court that recognized the contractual right that you have a right to contract. It's not enunciated that individuals have a right to contract, but we have the right to property, and how would you get to it? Um, and there's so this whole like, but it's been years and years that I've gone to that Lochner era cases or whatever those case names are. Um, but so this idea of this back to the gay rights part of it. Um, when you have so because of that case in the late 70s in San Francisco, there started to be state bans. Laws came out, and then there were cases: Bowers v. Harvick, Romer v. Evans, Lawrence v. Texas. Lawrence v. Texas was a case that before that, Bowers v. Hardwick and Romer v. Evans, they effectively just said no, there's no such thing as gay rights, whatever. you know, like uh, in Lawrence v. Texas, they said that there is a rational basis, which is what Roe versus Wade has been brought down to, from strict scrutiny to rational basis, which is, uh, which is, it's blasphemy. So uh, after Lawrence versus Texas, which was 2001, there was a huge amount. When did Oberfell come out? I think 2017. There was like 17 years of heavy, heavy activism. And I know this because I was part of that activism in a very droplet sort of way. Everything from marching to going to conferences as students in college, to marching in parades, to then me studying specifically gender history, history of masculinity in America, and American history, and American race and gender, and then onto law school, focusing on constitutional law. And so, and going into substantive due process, because it was personal, right? Because when I went to law school in 2005, there was nothing. I think when 2005, Don't Ask, Don't Tell was still law. Maybe no, I don't know. It's been so long now. I'm not an active activist anymore. I don't wave flags down the street and volunteer at um, um, nonprofits because I'm currently not in a position to do. But what I am in a position to do is explain to y'all what is happening, because you know they don't want you to be educated about it. They don't want you to know about it. They want to push you with by mislabeling and misguiding and misdirect you, and it's just it's abhorrent. And so I'm doing my best to do what I can, and you know clarify as much as I can for you in as simple as terms as it possible, because this is heavy topics and this is large topics. So yeah, after Lawrence versus Texas, there was so much activism that there were many states that recognized the right to marry, and slowly, we came upon Perry v. Ohio. Perry v. Ohio, it recognized um, gay rights, lifted it up higher um, than Lawrence v. Texas, but it didn't do enough. It didn't recognize gay marriage. It skirted the issue, and these are big cases. I'm not going to go into specifics. Then came Oberfeld v. Hodges, and in his last major opinion, Justice Kennedy wrote that there is a right to all people to marry. Same-sex marriage is a constitutional right. It's part of the emergence rights theory that we expand rights. The Constitution before Dobbs v. Jackson today or yesterday had never taken away a vested fundamental constitutional right. A fundamental constitutional right is one that gets strict scrutiny in the eyes of the court and the eyes of the law, and laws are designed to adhere to those strict scrutiny, which that the state has to have a substantial interest in drafting a law to limit that particular right.